A little adjustment this morning. We were supposed to be in the courtroom, and there's some new chairs or something being brought in, so I had to get YouTube pulled up. So it took me a little longer. I'm sorry. Okay, I think we have everybody we need. Carol Collins is involved in some other stuff. She sent me a report. I don't think she's going to be able to make this hearing, but I am aware of her report in her position. So unless anybody has an issue with that, I'm going to go ahead and call the case. In the 451st Judicial District Court of Kendall County, Texas. Court is broadcasting in Kendall County, but just from my office. And I am streaming this live on YouTube. Miss Garcia, would you please begin the announcements?
Alexis Garcia for the department.
Kim Coffey, Belong Adoption Specialist.
Laura Martinez, Adoption Supervisor.
Amy Harding, Hill Country Casa, Guardian Ad Litem for JC.
Miss Coffey and Miss Harding, if you both please raise your right hand. Thank you. All right. JC is the only child left in this suit. My understanding is that we kind of have a lot of the same stuff to report that we did back in October with just some minor behavioral changes. So, Ms. Coffey, the permanency goal is still relative adoption.
Yes, Judge.
And the placement with the Rassos is safe and appropriate, meeting her needs and her best interest to continue.
Yes.
It's the least restrictive placement available.
Yes.
And she's up to date on all of her checkups.
She is.
Her psychotropic review is up to date.
Yes.
Her educational needs are being met.
Yes.
How are her grades?
She's got good grades. She takes advanced classes, and I think she's got all A's and B's.
Okay. And last time we were here, she was getting therapy bi-weekly. How often is she in therapy now?
I believe it is every Wednesday. The therapist meets with JC and also with Miss Rasso.
Okay. Now I know we've had Miss Collins was concerned about some of JC's behaviors. And CASA had in their report that they think that a lot of these behaviors are pretty typical for someone in JC's situation. I think one of the things Miss Collins was concerned about was that maybe something from her past, maybe something from the trauma or that she endured was coming up. What belongs, I guess, you've been involved for a while. What is your take on her behavior? Is this pretty typical standard stuff, or do we need to get more intervention? What do you think?
So, Judge, I think most of her behaviors are typical. She's 14 now, typical teenage girl behaviors. There's a lot of hormones. I do, and I think she does very well, especially for what she's been through and through the foster care system and multiple placements. I think right now, last month when I talked with the family, they told me they were ready to adopt at the end of the school year. So like May, June time. I just met with them this week, and I guess Miss Rasso's got some more health issues that have come up. So she's really concerned that if something happens to her, she won't be around to care for JC. So that's something that's come up more recently. JC's behaviors, I don't think they're anything super concerning. But she is in therapy weekly, so I'm going to reach out with the therapist and just kind of see if maybe something has come up in the therapy sessions recently that maybe have triggered some trauma in her.
Well, and that was one of the concerns that Miss Collins had in her report, was this idea that maybe the Rassos were getting, I don't know, cold feet, getting concerned about moving forward with the adoption. do you think that it's to the level where we need to start looking at other placements, or do you think it's just kind of work with them and continue to monitor?
I think we should work for them. I know Miss Rasso, she's waiting for some test results and she has to have some other tests done. I don't want to rush anything right now. She had given me a timeline at the end of the school year, and I think by that time she should have her test back that she's waiting on. I certainly don't want to move JC, especially before the end of the school year. She's doing, really well in school, and she's got her friend group, and she's involved in extracurricular activities, and, they're able to care for her right now. I think Miss Rasso's I think she's worried about her own health. And JC being only 14 and just maybe not being around if something happens to her.
Let's talk about licensing. Last time we were waiting on a out-of-state background check that you had received, and it was going through processing, and there were some trainings that were going to expire. So where are we at with that licensing prong?
They are licensed.
Okay. All right. Okay, so this conversation that we had back in October where Miss Rasso kind of felt like JC was getting out of control. We're not there anymore. We're just
My opinion, I think a lot of it is typical teenage behaviors, little lies about things, just that middle school wants to hang out with her friends type of behaviors. I don't see any huge incidents or anything, like runaway or anything like that.
okay. And so I guess that would this is we're having kind of a candid discussion here. My concern is if we've been having these kind of reports from the placement since October at least. And now, Ms. Rasso is concerned about some health issues. It sounds to me like both Casa and Belong and Ms. Collins, to a certain extent, have a different view than Ms. Rasso of what these behaviors are. Would I be correct in saying that, or am I oversimplifying it?
I think they're more typical probably than Miss Rasso. And I've talked with her about it. I think there's just some defiance and back talk and things like that to me seem to be typical for her age and development.
Okay, and that's kind of what I've gleaned, and I would agree. I've spoken with JC, and I'm not hearing anything from you. I didn't read anything in the CASA report, and I didn't see anything in Ms. Collins' report that gave me great cause for alarm. What gives me concern is that we haven't even gotten through this whole process yet. And it sounds like Ms. Rasso has a very different perspective. And so I guess what I'm trying to be proactive about is, it sounds like you're saying no. It sounds like you're saying we're not quite at the point where we need to start looking for alternative placements. But is it something that we should have on the horizon? Are we that far along?
I think it would be a good backup plan to have to prepare for.
Okay. All right. Ms. Garcia, you have any questions for Ms. Coffey?
No, Your Honor, nothing further.
Okay. Ms. Coffey, besides what we've already talked about, are there any reasonable efforts that you want the court to consider?
No, I mean, I did talk with Miss Rasso that about any other family members or fictive kin that could care for her.
Okay.
She said not full time. There's a lot of family and support, but I guess that they could not care for her full time if something happened to her.
Okay. All right. Trying to find I don't know where I put that report from. Here it is. Okay. So no, that's not it either. Did you all get a copy of Miss Collins' report? Has everybody seen it?
Yes, Judge, I have.
Okay, Miss Harding is shaking her head no.
Yes, we have it. Sorry.
Oh,
Yes,
you do have it. Okay.
Yes.
So we don't need to go over it in detail then?
I don't think so.
Okay. Well, it sounds to me like Miss Collins is fine with placement continuing. She just had some of those reservations that we've already talked about. We don't need to go over it all again. Miss Harding, the CASA report seems to be mostly in line with that. Anything else that you want to add or any other requests that CASA might have at this time that are not in that report?
I don't know that we need any special orders from the court. My concern for JC at this point, and think that maybe some of, an undertone to her behavior is she's had so many adoptive placements that have gotten to almost consummation, and then all of a sudden the bottom fell out.
Yeah.
And, I'm concerned that she is fearful of that cycle repeating itself, maybe almost to some degree of a self-fulfilling prophecy, because that has happened time and time again. And so I do think that all of her needs are being met, and the Rossos love her and care for her, but their expectations for her behavior are, I think, stricter than what I certainly would be understanding of based on all of her history and her trauma. I think she's a pretty typical 14-year-old girl. She's got some extra sass, but it's not anything that, I'd be reporting something very different to the court if she were running away, if she were sneaking, drugs or any significant things of real concern that had a criminal behavior to it. And that's not what we're getting from her. I would like to maybe consider having a placement support meeting of sorts where we can get the extended family, if we could get the extended family members to come together, because the Rossos do have a big support system, and, really feel the situation out to see if there's somebody else that can take her in the event that we aren't able to consummate the adoption, because she wants to be with family. And I don't want to have to put her in yet another potential foster adopt home. I don't think that will go well for her because of all of the failed attempts previously. And that's my concern. So being able to do anything that we can to get this to consummation, I think, is necessary.
Okay, thank you. I'll find that the permanency goal of relative adoption is in the child's best interest, that her placement with the Rossos is safe, appropriate, meeting her needs, in her best interest to continue. Court finds that she's in her least restrictive placement possible. She's up to date on her medical, dental, and vision checkups. Her psychotropic review is up to date. Behaviors are, I think, overall typical, normal, for a child of her age and for a child who is in care. I'm not hearing anything that gives me cause for alarm. Court finds that her educational needs are being met and that her grades are good. Court finds that she's receiving weekly therapy and that is appropriate. Court finds that the placement is licensed and that Belong has made reasonable efforts by maintaining contact with the placement and JC, assisting with the licensing, keeping her with family, and exploring other options in the event there's an issue with this placement. Here's what I want to do with the Rassos and JC. I am going to order that support staffing that Ms. Harding suggested. I think that would be good. Let's do that within the next 30 days or sooner if we need to. But I'm also going to order that the Rassos go to 4 therapy sessions with JC. All 3 of them go to 4 therapy sessions, because I would hate to see a problem here. And because I agree with Ms. Harding that there's probably a pretty good potential for that whole idea of a self-fulfilling prophecy, or even some intentionally destructive behaviors to test the boundaries and just see, well, how much do you want me? I've seen it before, and I'm not saying exactly that it's happening here, and I'm certainly not a psychologist or a psychiatrist, but I've just seen it before. Children push and push and push because they want to make sure that the people that have them aren't going to give up on them. And I don't know if that's happening here or not, but I think that, one of the things that as an employee of the state I had to do was go to training on how the different generations communicate with each other. And, I don't know that they're communicating right. I don't know that the expectations that the Rassos have for a child of her generation are the best expectations to have. And maybe we could bridge that gap by exploring that in therapy. So I want them to go to 4 therapy sessions. And Miss Coffee, if you could put a bug in the therapist's ear, that I would really like for them to focus on intergenerational communication. I think that's important here. And expectations for how raising a child in 2025 is very different from every other generation, and we need to take that into consideration. Maybe that will help. Maybe it won't, but it's all I can come up with at the moment. Anything I failed to address, Ms. Garcia?
No, Your Honor.
Okay. We'll be back August 13th at 10:30 for our next hearing. August 13th, 2025 at 10:30. That's our next planned permanency review. Maybe we'll make some progress on some other fronts in between now and then, and we won't need that hearing, but we shall see. Okay. Thank you all for your time and your service. If nothing further, all parties are excused.
Turn on this video. How do you turn on the video? Oh, there it is.
And Ms. Savage, your client's incarcerated, correct?
Yes, Your Honor. Me and Miss Greenlee had organized for him to be here from jail. I believe they were going to call in, but I don't see him connected yet.
Yeah, I don't see them either.
I had sent in all the paperwork and I had spoken with TDCJ, but even despite an order, it is up to them, and if they have phones, guards, or however to get them here. So.
Okay, well, let's go ahead and call the case and we'll get everything on the record. In the 454th Judicial District Court of Medina County, Texas. Court is broadcasting outside of Medina County via Zoom and YouTube. Are there any objections?
No objection, Your Honor.
Objection.
Okay, with that then, Ms. Kyla Green, would you please begin the announcements?
Yes, good afternoon. Emily Kyla Green, attorney for the department.
Irene
Crystal
for the mother.
Crystal Rosales, investigator with the department.
Alexandra Vanderbilt, I am Ms. Rosales' supervisor.
Kathleen Savage, attorney for the respondent, Father Matthew Rodriguez, Your Honor. I have had contact with him, but he is not here today, so I'm going to announce not ready.
Marco Cabrera, attorney at Leiden.
Irene Acosta, attorney for the mother. I'm ready. Ms. Rodriguez, can you please unmute and announce?
I thought I already had muted it. Mine's
You just
already
need-
unmuted.
You just need to state your name, ma'am.
Oh, Apollonia Rodriguez.
Thank you. All right, anyone who's not an attorney or will be giving testimony, please raise their right hand. Miss Savage, you've been announced not ready. Do we have service on Mr. Rodriguez?
We do not have service on Mr. Rodriguez, Your Honor.
What I'm inclined to do then is grant her not ready, and we won't make any orders as to Mr. Rodriguez today. We can take that up at the status hearing. Hopefully by then he'll have been served and either appear that day or show up. Okay. Miss Rosales, just before we get started, my understanding is there's an agreement. There's no Indian child heritage in this suit, is there? That you're aware of?
No. No.
Okay, Miss Kyler Green, Miss Rodriguez is here. She was served, and her attorney is present. My understanding is you have an agreement.
We do, Your Honor. The parties agree for the department to be named as temporary managing conservator, and for the mother to be named as temporary possessory conservator. The parties agree to hold a family group conference to establish a family plan of service that's narrowly tailored to address the dangers that brought the children into the care, and for Ms. Rodriguez to participate in that. Parties agree to stipulate to the reasonable efforts listed in the affidavit, although it's my understanding that Ms. Rodriguez is not stipulating to the allegations in the affidavit. In regards to visitation, right now the children are pretty far away, but there has been a request for placement with the paternal grandparents, to which the department is willing to conduct a home study of the paternal grandparents. I believe the name is Michelle
Michelle and Alejandro Rodriguez, Your Honor, and they're present.
The paternal or maternal?
Paternal.
Okay.
And regarding visitation, Your Honor, the agreement is to have a normal supervised visitation to begin with, and then discuss further visitation as the case progresses.
Ms. Acosta, is that your understanding of the agreement?
It is, Your Honor. We would request that if the home study hasn't already begun, that it be expedited. The grandparents are willing to take all of the children, and they're present today.
Mr. Cabrera?
I'm in agreement with those terms as well, and I would second Ms. Acosta's ask for an expedited home study.
Okay. Ms. Rodriguez, I understand you may have things that you want to say or questions, but right now at this time, I just need to know if that's the agreement that you made.
Yes, sir, it is. It's exactly what we want.
Did you have the opportunity to discuss that with your attorney?
Yes, I did.
And were you forced in any way to agree to it, or did anybody make you any promises?
Not at all.
Are you asking the court to approve the agreement today?
Yes, please.
Okay. All right. And then I'm assuming y'all want to defer child support, medical support at this time?
That is correct, Your Honor. Thank you.
Okay.
And Your Honor, just a request as it comes to placement under 262-201N. If the court is not ordering possession by a parent or a managing conservator, then their children shall be placed with a relative unless it is not in their children's best interest. My understanding, the children are either in a group home or shelter of some sort, very far away. The paternal grandparents are active in these children's lives and they have a bond with them. They're also in the local area, which would help facilitate not only visitation, but allow the children to be returned to their school of origin. So I would ask the court to order placement, order the expedited home study, but to get these kids back home to their area where they're from.
And Your Honor, they're in a foster home, not a group home. The concern that we had is that there's things that popped up on the background check of the Rodriguez family, and so what we'll need to do is I think the correct terminology is like a risk assessment. So that needs to be done first and foremost. But we are willing to do the expedited home study.
Mr. Rosales, You heard the agreement. Do you believe that this agreement is in the best interest of the children?
Yes.
All right. And is the current placement safe and appropriate, meeting their needs?
Yes.
All right. What were just without divulging any potentially confidential, specific criminal history, or any other type of criminal history, what generally are the concerns that you need a risk eval for?
There was a conviction in the background check that we just need to be able to address, and more so be able to relate how it wouldn't affect the safety of the children currently.
Okay, so just to be.
Can I speak? Can I speak?
No, ma'am, you can't speak out of turn. If somebody wants to question you, they can question you, but it's not really a meeting. This is a hearing. We have procedures we have to follow. So, Mr. Rosales, you heard Miss Savage referring to the statute, and she is correct that barring any evidence that suggests it would not be in the best interest of the children to place with a family or other relative, family member or other relative, the court is under an obligation to place there. So is it your testimony today that the concerns requiring the risk evaluation rise to the level of giving you pause or concern about placing the children there at this time until that's been done?
Yes.
Okay. And do you believe, I understand, Ms. Savage, that your client under 262-013 does not agree to the allegations in the affidavit, but Ms. Rosales, do you believe that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the children?
Your Honor.
Yes.
Yes.
Just a clarification. It's Miss Acosta's client, not Miss Savage.
Well, no, but Ms. Savage did bring up the, I'm sorry, thank you for the clarification, but it was you, Ms. Savage, that brought up that placement issue, correct? Okay, all right. Sorry if I misspoke. All right, Mr. Rosales, do you believe that the urgent need for protection required the immediate removal of the children, and reasonable efforts consistent with the circumstances and providing for the safety of the children were made to eliminate or prevent their removal?
Yes.
And do you believe that reasonable efforts have been made to enable the children to return home, but there's a substantial risk of a continuing danger if the children are returned home?
Yes.
All right. I also understand the parties have stipulated to the reasonable efforts, but just for the purpose of this hearing and the record, could you please briefly set forth the reasonable efforts you made to try to avoid the removal?
Yes, we did try and engage mom in a safety plan. And after that, she decided that she didn't want further contact with the department. And we tried to reach her on different occasions at different residences, and we were never able to get a permanent residency on her to be able to have those meetings with her.
Okay. And other than what you've just stated, were there any other reasonable efforts made to enable the children to return home?
No.
So do you believe that the efforts that you just stated satisfied both avoiding the removal and attempting to return the children home?
Yes, we did also file the MTP,
Right.
and we're not able to get mom served to attend that.
Okay. Ms. Kyler Green, do you have any other evidence you want to present?
No, Your Honor, I don't have any more evidence. I don't know if the indigency findings from, or actually, I don't think there have been ever indigency findings on this case or for this individual. So I think that needs to happen as well.
Right. Okay. Anybody else have any other evidence they want to present?
No.
Okay. Ms. Rodriguez, I'm going to ask you to unmute again. Do you have the ability at this point in time to hire an attorney to represent you in this suit?
No,
Do you have anything that you own that you would be able to sell, or any savings, anything like that that would allow you the opportunity to pay for an attorney?
no, besides my car, but that's my, my go-to to get everywhere.
Do you receive any type of governmental assistance?
I used to, but once they removed my kids, they told me I could no longer, of course, they're not in my presence. I wouldn't be able to apply for a SNAP or anything like that. So that's the only
Okay.
thing I had was food stamps.
But when this case initiated, you were receiving that?
Yes.
Okay. I'm going to find that Ms. Rodriguez is indigent for the purposes of this suit and maintain the appointment of her attorney. Mr. Rodriguez is incarcerated, so I'll also maintain his indigency and continue Ms. Savage as his appointed attorney. Anything else that you want to report as the ad litem?
Yes, Your Honor. So I met with the children in the foster home. It's a good foster home. I don't see a real pressing need to move them immediately. They had a doctor's appointment. Isabel does have a physical disability with her right arm. She has a 504 accommodation for that in the school she's going to now. She had an R yesterday. Initial assessments for all kids are set up on Saturday. Kids are doing well. They're being taken care of. All of their needs are being met. As for the Rodriguez family, I have been kept abreast of what's been going on. My understanding is that the charges are serious in nature, but from some time ago. So I would agree with the department. It is something that we need to check on. If that's all that it is, and just that charge from long ago, then I would likely support the move. But just to ensure the safety of children, I think we do need to take those extra steps.
Okay. Ms. Rosales, do you believe that the educational needs of the children are being met in the current placement?
Yes.
And they're getting the health care they need?
Yes.
All right. Then based on what I'm hearing at this point in time, court finds that the agreement of the parties is in the best interest of the children. Again, based on 262-013, the court will enter this agreement with the condition that mom is not conceding to the truth of the allegations in the affidavit. The court will find that based on the testimony here today, that there was a danger to the physical health or safety of the children caused by an act or failure to act of the person entitled to possession for the children to remain in the home is contrary to their welfare. The urgent need for protection required the immediate removal of the children, and reasonable efforts consistent with the circumstances and providing for the safety of the children were made to eliminate or prevent the children's removal, and reasonable efforts have been made to enable the children to return home, but there's a substantial risk of a continuing danger if they are returned home. Court finds that it's in the best interest of the children to name the Department of Family Protective Services and belong as the temporary managing conservator of the children, to name the mother as the temporary possessory conservator of the children. Court will make no orders as to Mr. Rodriguez at this time. Do we need a DNA test?
No, not at all.
Ma'am, I wasn't asking you. I understand that you want to answer that question, but I'm not asking you. Mr. Rosales, do we need a DNA test?
Not at this time.
Okay. And Ms. Kyler Green, was it the intention of legal to ask for one?
It wasn't, Your Honor. He's the presumed father. I don't think one's necessary at this time.
Okay. All right. The reason I asked that question, Mr. Rodriguez, is because if we don't ask it at the beginning, there could be an issue later that would cause delays for you. And I don't want that to happen. I understand from a practical perspective, there's no doubt, but the legal part of it is very different and we have to follow certain steps. So I just wanted to get that out of the way. All right. And then the court will order the parties to attend a family group conference to develop family plans of service that are narrowly tailored to address the concerns that brought the child into care. court will also order the expedited home study on the placement. This is for Ms. Rodriguez and both her and the paternal grandparents. The issue we have before the court is that there's a possibility that there may be something in the past that would, in certain circumstances, cause a bar to placement. It sounds like that's not going to be an issue here, but this is why I'm inclined to let that happen before I order placement. And that's a best interest issue. What's in the best interest of the children? If I were to place the children there today and that placement happens, and then this risk evaluation is done, and there's a problem that causes the court to have to remove the children again, that's not only bad for the children, but it could possibly cause a problem for us placing the children there again and getting any potential funding that might be available to assist with the placement. So my hesitancy is not because I want to make things more difficult. It's because I want to avoid a bigger difficulty in the future by not taking a small step now. The evidence is that the children are doing okay where they are. They're having all their needs met. I'm ordering that home study to be expedited, which would include the risk eval being expedited. So if all that comes back, then we can get this move done, and then we've taken care of both issues so that we don't potentially have an issue coming up after the fact, causing us an even bigger headache. Does that make sense? Okay. All right. Then I'm going to order that the children remain in the placement, the foster home, find that it's in the best interest of the children, it's meeting their needs to remain there, and that it's safe for them. But I want to make it very clear. I want this expedited home study to be expedited, and I want the risk eval to be expedited. And the second you get clearance, the children need to be placed with family.
And Your Honor, can I ask for that to be I think it's 3 days, the quickest expedited home study, if I could have that in the records.
I'll order that unless there's something that, like a paperwork issue that's outside of the control of Belong or the department. If they absolutely cannot get that done, then I'm not going to find them in any kind of contempt if it's a factual impossibility for them to meet that deadline. But I would prefer it to be 3 days as well. I don't want these children to be in a foster home any longer than they need to be if we've got appropriate family. Not only do I not want that, but technically that's the obligation under the laws for us to get the kiddos there as fast as possible. I'm going to defer child support and medical support at this time. And I'm going to order that mom have visitation twice a month for 1 hour supervised, with the caveat that if they are placed with the Rodriguez's soon, which hopefully they are, that the visitation I'm going to authorize you all to increase it as appropriate based on mom's engagement. So what that means, Ms. Rodriguez, is if you engage in these services that you develop with the parties and you're maintaining appropriate contact with your caseworker and your permanency specialist, and everybody can get a hold of you, and you're testing, if you're being drug tested, that you're testing, then the parties can agree, the parties can agree to slowly increase the visitation more than just twice a month for an hour. If you don't do those things, then it's going to stay there. So that is your motivation to continue to prove to the parties and then to the court when we come back for our status hearing that it's safe for you to have
only
those visitations. Hang on, ma'am. Hang on. Don't speak out of turn. The court will order that authorization at this time, and I don't want what I just said to change the fact that if that risk eval turns something up that we don't know about right now, if there's a genuine concern, just because I'm saying we need to get the kids there as soon as possible, that I'm not overriding any concerns that might come up that the people in this room are not aware of right now. So it's not a 100% guarantee. It's just that we need to take that step. Miss Acosta, your client has a concern. Do you want to question her about it?
Prior to doing that, Your Honor, can I just make one request?
Yes.
With regard to the visitation, can we be ordered to discuss that as well at the FGC? Because I know right now the children are placed far away, and that's why the 2 times per month was agreed to. I just want it to be something that's a continuous conversation.
Yes, I think it would be very appropriate, and I want Mr. and Mrs. Rodriguez, the grandparents, to be a part of that FGC. I'm ordering that. I want their input in it as well. I think that discussing the visitation the visitation needs that are specific to this case is definitely something that should be on the forefront of the parties' discussions on the case and then the FGC. So yes, that's great. Did you want to ask her a question? I'm not sure what her concerns are, and I just don't want her to put anything on the record that.
I don't, Your Honor. I'll speak with her after the hearing.
Okay. All right. Our status hearing is going to be April the 8th, 2025 at 10:30. April 8th, 2025 at 10:30. So what that means, Ms. Rodriguez, is that between now and April the 8th, which is a little over a month, a little less than a month, you're going to have a meeting with all these people, and you're going to develop a plan that you have input in, your attorney has input in, that will be tailored to this specific case and your children, your needs, their needs, to determine what sort of orders I'm going to enter at that status hearing on April the 8th. So you need to make sure you're at that meeting and that you work with the parties and cooperate to figure out what sort of services can be ordered that are workable for you and that address the concerns that brought the kids into care so that we can fix this issue and streamline this case as much as possible. I have to admonish you that the state of Texas gives parents in child welfare cases 1 year to demonstrate that you can provide a safe, stable, violence and drug-free home for your child. If you can't do that within a year, then your rights to your child are subject to restriction or termination. Our year started on the date that this court signed the emergency order, which was March the 4th, 2025. The year is going to be over on March 9th, 2026. It doesn't have to take a year. It doesn't have to take that long, but that depends on what you do. I don't know how long Mr. Rodriguez is going to be incarcerated for, but regardless of how long it is at this point in time, you know that you're the parent right now that has to provide a home for these children. So you are on a pretty quick timeline, and you got to take advantage of all that time. You got to hit the ground running and work hard. Miss Kyler Green, is there anything I failed to address?
No, Your Honor. Thank you.
Okay, that'll be the order of the court. And I look forward to seeing what kind of progress we've made March the 8th at 10:30. Ms. Rodriguez, these cases can go really quick. They can go well based on the amount of work that you do and the willingness that you have to address issues. Even if you don't want to, if you're willing to address those issues, then these things, they're a lot easier than if you're defiant or combative. So really think hard about the choices that you make. I believe in you. I've seen a lot of parents in your situation who worked really hard and did what they needed to do, and things worked out well. So you can do this. All right. Thank you all for your time and your service. Mom, don't have Mr. Gorley here.
I do know, Your Honor. He just messaged me. He's trying to log in. He's trying to figure it out.
Okay. We'll see if he gets in. Hopefully he does. All right. Court 198, Judicial District Court of Bandera County, Texas. Court is zooming and streaming via YouTube from Medina County, Texas. Any objection?
No, Your Honor. No, Your Honor.
Okay. All right. Then with that, Miss Hellrung, would you please begin the announcements?
Yes, Your Honor. Cecilia Hung on behalf of the department. There was a adversary mediation, and we do have a mediated settlement agreement that we would like to get on the record.
Alana Pearsall, attorney for the mother, Emily Roberts, was present, and we are ready, Your Honor, and I agree there is nothing to say. Mr. Roberts, will you state your name, please, and then put yourself on mute?
My name is Emily Roberts.
Deborah Fuller, attorney ad litem for the child. Ready, Your Honor.
Goldie Robson, Hill Country Coffee and ad litem for the child.
Kurt Rudkin for Mr. Gorley.
I don't think we just got him into the room. Mr. Gorley, can you unmute and or turn on your video? All right. Can you unmute for me, please? Would you state your name for me, please?
It's William Gorley.
All right. If you could, keep that device as still as you can, okay? All right.
Yeah.
Anyone who's not an attorney or will be giving testimony, please raise your right hand. Ms. Roberts and Mr. Gorley, I need you both to please raise your right hands. Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes, Your Honor.
Thank you. Miss,
Yes, Your Honor. Sorry.
thank you. All right, I'm going to mute you, Mr. Gorley and Miss Roberts. Miss Hellrung, what are the terms and conditions of your MSA?
Yes, Your Honor. The first substantive provision is that the Department of Family Protective Services will be named the temporary managing conservator of the child, and the mother will be named temporary possessory conservator. Belong shall set up a DNA test for the alleged father, William Gorley. Alleged father will be ordered to submit to a DNA test set up by Belong. The parties are agreeing to waive child support and medical support. A family group conference will be held on April 1st, 2025 in person to set up a family plan of service. The department shall provide transportation. The department agrees to offer virtual services, any services including visits that must be completed in person. Belong will provide transportation as long as mom provides 24-hour confirmation to Belong that she needs transportation. All visits shall be for an hour and a half every Thursday at the Bernie Department of Family Protective Services office. The length of time can be increased by agreement of all parties in compliance with the family service plan. Should mom miss, reschedule, or fail to confirm any visitation shall revert to 1 hour twice per month. Mom will submit to a hair follicle by Friday, March 28th, 2025 at 5 p.m. The department will provide transportation. Parties stipulate that under 262.013, that by agreeing to this MSA, the mother does not submit to the veracity or truthfulness of the allegations in the affidavit. The department agrees to do an expedited home study on any individual that passed the initial preliminary check, and all parties agree to their electronic signature. I do not know if any names have been provided to Belong. I do see that Ms. Kraus, the investigative supervisor, as well as Alejandra Zertucci, the Belong permanency specialist, are on this feed, but I can ask them if they've received a request for a home study.
Your Honor, we haven't provided any names.
Okay, that answers that question. All right. Is that the entirety of the agreement?
It is, Your Honor.
Have both parents been served?
If you give me one moment, I'm going to check my system.
Okay. Well, I can find that they've made an appearance as long as they've agreed to this. But I'm just curious if they were served or not. Okay. Ms. Pearsall, is that your understanding of the agreement?
Yes, Your Honor.
Mr. Rudkin, is that your understanding of the agreement?
It is.
Ms. Fuller?
Yes, Your Honor.
Casa?
Yes, Your Honor.
All right. Is Miss Kraus the investigator?
No, Your Honor, I'm the investigative supervisor.
Okay, who is the investigator on the case?
It is Esther Coleman. I believe she said she was on, but she may have had some issues.
Okay. I don't see her anywhere on here.
Your Honor, I did just check the system. All I see in the system is that service was requested, but I do not see a return of service in the file.
Okay. Well, Ms. Kraus, can you provide some quick testimony for me?
Absolutely, Your Honor.
All right. Are you familiar with the facts and circumstances of this case?
Yes, I am.
Did you hear the agreement that Ms. Hellrung announced on the record?
Yes, I did hear the agreement.
Do you believe that this agreement is in the best interest of the children?
Yes, I do believe at this time that is in the best interest of the children.
Is the current placement safe and appropriate for the children?
Yes, it is.
And in their best interest, or the child, excuse me, is in the best interest of the child to remain there at this time?
Yes, it would be in the best interest at this time.
All right. Do you believe that there was a danger to the physical health or safety of the child caused by an act or failure to act with the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child?
Yes, Your Honor.
Do you believe the urgent need for protection required the immediate removal of the child?
Yes, Your Honor.
And do you believe that reasonable efforts consistent with the circumstances of providing for the safety of the child were made to eliminate or prevent the child's removal?
Yes, Your Honor.
And do you believe that reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home?
Yes, Your Honor.
Do the parties stipulate to the reasonable efforts section in the affidavit?
Yes, Your Honor.
Okay. I'm not hearing any objections to it, so I'm going to assume everybody will stipulate to the reasonable efforts that were made in the affidavit. Do you have any other knowledge of any specific reasonable efforts that were made in this case to avoid removal and return the child home that are not in the affidavit, Ms. Kraus?
Not to avoid the removal. I do believe, since the removal, the belong worker Alexandra has tried to go out and assess the home, but has been unsuccessful at doing so, despite setting up some appointments that have been canceled or rescheduled.
Okay. All right. Mr. Gorley and Ms. Roberts, I'm going to ask you both these questions at the same time. I just need you to answer out loud for me, please. Did you both hear the terms of the agreement that was stated on the record?
Yes.
All right. Did you both have an opportunity to participate in the mediation and come to the agreement stated today?
Yes, Your Honor.
Yes.
Did you both have an opportunity to discuss it with your attorney?
Well, I didn't get to talk to my attorney at all.
Well, that's why I was interjecting. Mr. Gorley did not participate in the mediation. Did not participate in the mediation. So I entered into an agreement on his behalf for the DNA testing, but has no other issue. So I just wanted to make that.
That's right. And I should have rephrased my question. So Ms. Roberts, you spoke with your attorney about this agreement, correct?
Yes, Your Honor.
All right. And Mr. Gorley, you've agreed to do the DNA testing.
Well, Honor, I reached out to this attorney and I called him on the number that the lady Esther gave me, and I left messages, and I kept getting a voicemail and everything, and I never got no response back, but I agreed to giving the DNA test.
No, we called back several times and never got an answer. So that's where that's so.
Okay. So he's going to do a DNA test only. Miss Roberts, did you make this agreement voluntarily?
Yes, Your Honor.
Were you forced in any way to agree to this?
No, Your Honor.
Did anyone make you any promises to get you to agree to it?
No, Your Honor.
Are you asking that the court approve your voluntary agreement today?
Yes, Your Honor.
Okay, thank you. All right, then based on the agreement of the parties and the evidence that I've heard today, I'll take judicial notice of the affidavit that the parties stipulated to. Court will make the findings pursuant to the family code full adversary hearing that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of a continuing danger if the child is returned home. Court finds that the agreement of the parties is in the best interest of the child, that the placement is in the best interest of the child. Court finds that the placement is safe and appropriate, meeting the needs of the child. Court finds that the department and belong shall be the temporary managing conservator of the child. Miss Roberts, the mother, shall be named as temporary possessory conservator of the child. Court makes no orders as to the father, Mr. Gorley, at this time, other than ordering him to submit to a DNA test to determine his paternity. At this time, the court will waive child support and medical support for both parents. Order the parties to participate in the family group conference as agreed in person. And I'm not going to repeat every single thing that Ms. Hellrung said on the record. I know she was reading from the agreement, so that's going to be the order of the court as far as all those particulars are concerned. I'm going to find that the parties have agreed to a 262-013 caveat that by agreeing to this, the mother is not admitting any of the allegations in the affidavit. I find that reasonable efforts have been made, and not only what's in the affidavit, but any attempts that have been made to try to find an alternative placement by belong. I have to admonish the parents that the state of Texas gives parents in CPS cases, child welfare cases, 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction and or termination. What that means is that you've made this agreement, Ms. Roberts, and based on your paternity, you may be making this agreement too, Mr. Gorley. You have 12 months to address the things that brought us here. And you have to follow the orders that are made. So you're going to go to this family group conference and you're going to create these family plans of service. And these family plans of service are going to be used to make an order of the court when we come back for our status hearing. And actually, what date did you say you're doing your FGC? April 21st?
I think it's April 1st.
April 1st. Okay. All right. So we'll be here on the 11th to go over whatever you created on April the 1st. And once I make those orders, you've got to get these services done, because if you don't get it done within the timeline, our dismissal date on this case is February 23rd, 2026. It's February 23rd, 2026. This case technically started by law on February 21st of this year. So the 23rd is a year later. If we don't have it all figured out, then your rights might be subject to termination or restriction. So we need you to pay attention to what your caseworker needs you to do. Follow up on referrals. If you have transportation issues, you need to let them know, since that's a part of your agreement. And just make sure that you're staying in touch with your attorney as well. I'm going to find that by their agreements and their appearances here today, that both parents have made a general appearance in this suit. Department/belong is relieved of any obligation to further attempt to serve them. We'll be back for our status hearing April 11th, 2025 at 2:30. April 11th, 2025 at 2:30. Ms. Hellrung, is there anything I failed to address?
I don't believe so, Your Honor. Thank you.
Okay,
Your Honor, I just like to give an update on the baby.
please.
Okay. She's doing extremely well. She's a beautiful little baby, and I'm hoping that Miss Roberts is able to make all the visitations. The foster parents have set up like a Google Photos thing, so that if the parents can, have an opportunity to see daily photos and things of the baby since she is an infant. She's barely a month old. But she's doing really well in their placement.
Okay, good. Ms. Rapson?
Yes, Your Honor, CASA was able to visit in the home, and we believe the placement is in the child's best interest. She's doing well. And we are also hopeful that the parents can sign into this Google Photos. It's very generous of the foster family to do that for them.
Thank you. Ms. Coleman, I know you're having some trouble getting in. Anything you want to add?
No, Your Honor.
Okay. All right. Well, then thank you all for your time and your service. Ms. Roberts, Mr. Gurley, it might seem like it's really difficult right now, but you can do this. You can do it. I've seen parents do it. I've seen parents work all this stuff and get their children reunified with them. And it doesn't have to take a year. It just depends on what kind of work you're willing to do and what sort of effort you're willing to make. Okay. But you can do it. I believe in you. Okay. That'll be it. I'll see you all April 11th at 2:30. Nothing further. All parties are excused. And
Thank you.
You're welcome. Ms. Pearsall, I can hang out just for a minute.
Thank you, Your Honor.
Father.
Thank you.
Oh, David, while I have you there, I did call both both fathers of Nevaeh and Zanea and talked with them, and we'll try to get together. But they were both girls were very happy to hear from Christian, and both fathers were also said they were looking forward to seeing Christian again and getting it.
Yeah, they really love their brother. That is one relationship I did not want to see broken.
Well, it won't be. We'll do.
Good
It's just
morning.
that we have so much going on right now. I'm sorry.
In the
I can't hear
198
you.
Judicial District Court of Kerr County, Texas. Court is in Gillespie County today, so I am on Zoom and YouTube. Before we proceed, are we going to be getting into potentially confidential medical issues today?
I don't believe so.
Are you, as the ad litem and Mr. Nelson as the guardian ad litem, are you comfortable with the information that's being discussed in this hearing for Christian today being on open to the public?
I think for today's purposes, yes, Your Honor.
Yes, sir, I'm fine with it.
Okay. Any objections to the court streaming from Gillespie County via Zoom and YouTube?
No, Your Honor.
No, Your Honor.
All right. Then with that, Ms. Thompson, would you please begin the announcements?
Jessica Thompson on behalf of the department.
Kim Coffey, Belong Adoption Specialist.
David Nelson, CASA guardian ad litem.
Kathleen Savage, Attorney Ad Litem.
Goldie Rabson, Hill Country CASA Guardian Ad Litem Supervisor.
Joel and Pam Rosen, we're the foster parents.
Okay. Anyone who's not an attorney or might be giving testimony, please raise your right hand. I get the Rosens to please raise their right hands as well, please. Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
I do.
All right, thank you. Okay, we've got a progress hearing today just to check up and see how things are going since we've made some changes as of last hearing. Ms. Coffey, do you need any orders today? Is there anything that you're requesting, and what is the current status at this time?
Judge, at this time, I don't believe that we need any special orders today. Christian is currently residing with the Rosens. I placed him there about 3 weeks ago. right after our previous hearing, and he is doing well there. He's adjusting to the new placement. We did expedite a home study, a kinship home study that has been approved. And they will be working, I believe it's with Arrow, to become licensed. But he's doing fairly well in the home, you know, learning the rules and the new placement. He's attending school. And that's about where we are right now.
Okay. Miss Thompson, do you have any questions for Miss Coffee?
Yes. How is Christian doing in his new placement?
He's doing well. I think he's getting more comfortable with the Rosens. He's, you know, talked openly with them. You know, just getting used to new rules after being in, you know, in the hospital for a couple months. Just getting used to, you know, a parental figure having rules and things like that again.
No further questions, Your Honor.
Miss Savage?
No questions, Your Honor.
Anything else from Belong, Miss Thompson, or the department?
No, Your Honor.
What are your thoughts, Miss Savage?
I am so happy we found the Rosens. They're both very knowledgeable in the medical field, and Miss Rosen specifically on the foster care side. Christian, I was able to visit with him in the home this weekend. He is settling in nicely. I got onto Christian's case later, but I think this is the first time he's been in a foster home setting. So I'm really excited for him to be in a home and be able to get back to school. He did vocalize because they put him in the special education classroom that he felt he was too advanced for some of those homework assignments and to be around some of those kids. So the Rosens have talked to the school to, you know, make the work a little harder for Christian because it was too easy for him. So he's doing really well though, and they're working to maintain those sibling connections. So I'm really happy with where he is, and you know, he's got a great team behind him, and he's stayed local. So I couldn't be happier. Their home study came back approved, so I think it's, you know, everything's smooth sailing at this point.
Wonderful. Mr. Nelson?
Yeah, I'm very pleased where he is. I did go visit the house and talk to Mr. Rosen and to Christian and Pam, and I was very pleased. I just talked to Mr. Rosen. He told me that they did contact the fathers of Nevaeh and Zanea, and that Christian had a really good conversation with the girls, and I was pleased to hear that. So, and they're very pleased. So, I think all is going well.
Wonderful. Thank you, Mr. Nelson. Do we need progress hearings every few weeks, or can we spread it out? What do you think? Ms. Coffee, what do you think?
Judge, I don't believe that we need to continue every couple weeks with progress hearings. He will have a medical procedure early to mid-April. I don't know if you would want to update after that.
We have at the end of April.
And Your Honor, I would agree. I don't think we need the bi-weekly or bi-monthly progress hearings. I think we could do much further out.
Agree, Your Honor.
I think what I want to do for this next one is give it let's start with a month, just since he's in a new placement and he's going to have a medical procedure. And then from that point on, we could probably move it out to every few months. Okay. We got anything a little later than that? Okay. What about the beginning of May? We'll come back May 21st. What time? At 9:30. It's a little longer than a month, obviously, but if you all need something sooner, you can let us know. That's the best time we have between now and then for a progress hearing. Okay, well, just stay in communication with each other. Mr. and Mrs. Rosen, thank you for what you're doing. Everybody just let each other know what's going on. If there's any issues, let's get in front of them before they get worse. So hopefully we can be on smooth sailing here. I hope his medical procedure goes well. And thank you all for your time and your service. If I don't hear anything before then, I'll see you all May 21st at 9:30. Thank you. All parties are excused.